So let's talk about the case brief assignment. We did talk about it in class, but if you're anything like me, I need to hear things a couple of times. So I thought this might be useful to have as a resource to look in on. So what is a case brief? A case brief is a tool. It's used in law school. In fact, if you are going to law school, this is something that you'll see. But I want to stress that it imparts important skills to everyone. Everyone could benefit from being able to do an effective case brief. It's essentially just a summary of a case. Supreme Court cases can be really long, and it helps you understand the case as you're synthesizing it into just 1, 2, 3 pages. And that way, like if you were in a discussion about the case, instead of paging through 100 pages, you just have the essence, the most important parts right in front of you. The reason case briefs are hard, especially your first one, and it can feel a little overwhelming. So why would I have you do something that's kind of painful, at least the first one? Because this skill, whether or not you ever intend to practice law, the ability to look at complex information, to understand it, and then distill that into a succinct, clear way is essential for any kind of job where you'll be managing things or might be expected to present an overview of information. If you can do this well, you will be quite successful at whatever it is that you do. So this is, take heart, because the skills that you're gaining here, the critical thinking, the ability to spot important issues and the relevant from the irrelevant, this is just so important no matter what it is that you decide to do. So let's talk about the components of case brief. These are in your written guidelines, but I thought I'd just pull them out so we could look at them here. One thing about formatting, this is one of the few assignments you'll have where I'm going to ask you to do it single-spaced. I imagine, and this is just kind of traditional, I imagine because case briefs are so often done for oneself to help you understand, and then later understand a whole bunch of the cases, a whole area of cases by just reviewing these couple page summaries of each one. And that way you can have it in less space. So go ahead, and we're going to follow that tradition, but do label each of these sections with the same labels I have here, like label the section facts, procedural history, and so forth. And so the first part, it's simply the name of the case. So using as my example here, Employment Division versus Smith, the names of legal cases are always italicized. The first name in the case is referred to as the petitioner, and the second name in the case is referred to the respondent. The petitioner is someone who's asking the court to look at this issue. They're the ones, the name that's first in the case, they're the ones that have dragged everybody into the courtroom. And the respondent is simply the one that's being forced to respond to this person who's dragged it into the courtroom. So when we see a Supreme Court opinion, we know a little bit about it already just by the order of the case names. So for example, we know that in the court that most recently heard the case before it got to the Supreme Court, that Employment Division was the one that lost. Because you don't instigate another round of hearing something in a court if you won below. So Smith won below, but now Employment Division is hoping that the next court, in this case, the Supreme Court, is going to reverse it, and perhaps they can win. Then the other part of the citation is this number here, and this is how a case would be located. It's a little bit of a dated method because we based this citation method on books. So yeah, I know, it's crazy. So this middle letters are referred to as the reporter, because at one time, if we go back to the late 1700s, early 1800s, when cases were first being handed down by appellate courts in the United States, it was usually some person who thought it would be a good idea to collect these things. And after you got a certain number of them, they would put them together and bind them into books or volumes. So this US stands for US Supreme Court Reports, and other federal courts, the volumes would be different and have a different name. But from that number, you'd know which set of volumes to go look at. And then you'd know which particular volume within that set. So we go to the Supreme Court reports, and then we look for the 494th volume. As Supreme Court opinions are handed down, when they become about this thick, then the decision is made to bind them, and they're set on the shelves in the library. So if we were in a library, we'd say, oh, okay, I know which set of volumes to go to, and then I'm going to look for the 494th volume. And then this next number refers to the page number that the case starts on. So once I find volume 494, then I'll flip through to 872, and that's going to be the first page of Employment Division versus Smith. And then this last part of the citation is just simply the year that the opinion was handed down, and it's done parenthetically. The facts of the case. This is a simple statement of what happened that got this thing brought into court. You should just pick out the cases or the facts that the case is really hanging on. Why is this important legally? Who did what? Who got sued for what? Who got arrested for what? And it should be anywhere from 1 to 3 sentences, and it really shouldn't be much more than that. If it's much longer than that, you're including irrelevant facts. So just the facts that makes the case that we're going to talk about make sense. And then we go on to the procedural history. This sounds a little more complicated, but it's how did the case get to the Supreme Court? In other words, where has it been? What was the process it went through? And really, we're just talking about who sued who in which court and who won at the lower courts below. So this is the example that is in the example case brief that I wrote that's in the guidelines. And you might want to take a look at that because I've written a complete example to try to show what these things look like in real life. So essentially in Grease versus Galloway, which was the case here, somebody named Galloway had sued the city of Grease in a federal district court, and they said that the town, because it was holding these legislative prayers at the beginning, or these prayers at the beginning of these legislative sessions, that it was violating their Establishment Clause rights. They lost. The court voted in favor of the town of Grease. So because they were the losers, so again, they're the petitioners, because they don't like that outcome. So they appeal it to the federal court, the Second Circuit Federal Appeals Court. This time, that court reversed it, and they said, you know what, Galloway, we think that you won. This is a violation of the Establishment Clause. And so now that Grease was the loser, they wanted to be the petitioner and asked the Supreme Court to hear the case. And that's always where you're going to stop this procedural history, is once they've asked the Supreme Court to hear it, because that's what the rest of this case brief is about. So the question before the court, or the legal issue, this is just simply, what are they asking the court to decide? So a good format for that is, does X, whatever it is that happened, violate the takings clause of the Fifth Amendment, let's say? In the Grease versus Galloway example that I was talking about a minute ago, a way of stating that, the question in that case would have been, does a prayer in a legislative session of a town council meeting violate the Establishment Clause? You can say these things really simply and say it in a way where the answer is yes or no. Yes, it does violate. No, it doesn't violate. The next thing that you're going to include is the holding or finding. Sometimes this is called the disposition. In other words, the court found that no, X does not violate the takings clause of the Fifth Amendment, or no, holding a prayer before a legislative session at a county commission meeting does not violate the Establishment Clause of the First Amendment. So the holding is always just a sentence, unless there were multiple questions asked. And sometimes that's the case, but in general, we'll just be focusing on that central question. The rationale, this is the most important part because this is where the thinking comes in. This is where the court explains why it decided that no, this takings clause was not violated, or no, the establishment clause wasn't violated. Why? Why do they decide it that way? This is where they're going to lay out their argument. So things that a rationale might include, depending on the case, is which were the precedent cases that the court really focused on as being most important. How did the court apply those rules in this case? How did they explain from these precedent cases which rules they were going to rely on? And how did they say that this case makes it different from previous cases? Because this case has obviously brought up something just a little bit different than previous cases, or else we wouldn't be at the Supreme Court deciding it. The next part is, what interpretive method did the court use to help itself understand what the Constitution means? At the beginning of the semester, we talked about the 4 interpretive theories that your textbook uses. And I won't go over those again. I've got them up on the screen, and they're, you did your first reflective writing on this, just kind of explaining what they mean. And so when you look at the decision and at the rationale of the majority opinion, oh, by the way, that reminds me of something. When you're doing the rationale, as it says in the guidelines, you're going to spell out the rationale of the majority opinion really clearly and in more detail. When it comes to concurring or dissenting opinions, a sentence or 2 for each of those will suffice. And I just created another video talking about what the 4 kinds of Supreme Court opinions are: majority, unanimous, concurring, and all of that. So take a look at that if you get a chance. So back to interpretive method. Just look in that opinion. Does it, when it's ambiguous about what it means, do they talk a lot about intent, in other words, originalism, or do they really focus like on some concept like, what would liberty mean in this instance? In which case we might say, well, that's like a moral reading. Or do they look at, you know, what is, are they talking about what does due process mean? And is the procedure fair? Or they might have spent a lot of time looking at, okay, what impact, if we decided this way, what impact would it have on society as opposed to if we decided it this different way? This is hard. I'm just looking for a good faith effort to think about how the court is thinking about it. Sometimes you can locate more than one. Sometimes it honestly might be hard to locate because the court doesn't use these labels about itself. It's scholars that try to label these things. In fact, judges will say, oh, I don't use any of that stuff. I just see what the law is. So do the best you can with that. The rule of law established. This is probably, when you first start, the trickiest thing. But what is it that the court did that matters for the future? In other words, when we look back at this case, or when judges or lawyers look at it, what lesson do they take from it that they can apply in this case? So in the Greece versus Galloway case, you know, the rule of law is that these legislative prayers, even sectarian ones, don't violate the Establishment Clause. And that was kind of the new twist to it, even sectarian. And because legislative prayers are different because they rely on history, something like that. It can be a little bit tough. Again, I'm looking for good faith efforts. You'll get better at this. It'll become easier. By the second time, you'll almost be a pro. It'll be much better. And then finally, this last part, this is the easy part. You just write a few sentences on what you thought of what the court did. You might talk about how it was written and the logic they used. You might want to talk about the outcome. You might want to talk about, I found this kind of surprising. I found it irritating. I didn't understand what was going on. I'm just looking for think about how they thought about it and what you thought about it, how they thought about it. And that sounds all kind of convoluted, but that makes it sound more like something we'd be talking about in this class. Anyway, I'm excited to see what you did with these. It's hard, but it's so valuable, and you'll have such a good understanding of the case after you finish this process. Okay, talk to you soon.